Good afternoon, ladies and gentlemen. I'm Laurel Evans, a program planning lawyer with the Law Society's Continuing Legal Education Department. While people are filtering in, I'd like to just welcome you today to today's program, Court-annexed ADR, the New Practice Direction. The program has been jointly sponsored by the Law Society and the Canadian Bar Association, Ontario. I'd like to begin by taking this opportunity to thank today's distinguished faculty, not all of whom are visibly present here this afternoon, for their time in coming here to speak to you today, and also for the time and effort put into preparing the presentations which you're going to hear. Keep the day rolling in accordance with the time schedule. I'd like to now introduce you to the chair of this program, Mr. Donald Short. Don Short is a partner with Fasken, Campbell and Godfrey and is certified by the Law Society as a specialist in civil litigation. He has lectured to the Bar Admission course and has chaired and participated in a number of Law Society and Bar Association programs. His articles have been published in Business and the Law and in the Advocates Quarterly. He's currently a member of the Commercial List Users Committee and the ADR Pilot Project Task Force. Thank you very much.
Good afternoon. In order to save time, I commend to you the biographies of the various speakers which appear at the front of the book. For the rest of the afternoon, I will give them a very brief introduction because I think you'd rather learn about the ADR than about their background, my background having been fully given to you already. The practice direction which you are here with respect to appeared in the March 25th edition of the Ontario Reports. This is the fastest CLE program to ever follow a change in the law in the history of the province. You will find it in the ORs that will hit your desk in the mail probably tomorrow. It is the citation which, for those of you who will need it eventually, is 16 OR 3rd at page 481. And that's where the practice direction appears. Those of you who have been at programs that I've chaired before know I have a reputation for running them like a railroad. The timetable that you see in your materials is the timetable that I will adhere to. I have told our speakers that, and they understand that they're to fit into the timetable. There will be a coffee break at 3 o'clock, and we will take your questions at the end of the program, but if you have any questions at the coffee break, let us know and we'll try and address them. Chief Justice McMurtry has been a supporter of the ADR program since it first came into concept as something that was worth looking into. And we're honored today that he's been able to find time in his schedule not only to address us, but also to stay for this program, to hear your views and also to see what the pilot project actually looks like. So without further ado, Chief Justice McMurtry.
Well, thank you very much, Don. And ladies and gentlemen, I, of course, am delighted today to have the opportunity of introducing this important seminar related to the Alternative Dispute Resolution Project. At the outset, I'd like to thank each of you for taking the time from your practices to be here, knowing how difficult it is at this time of year to find the time. However, I am confident that our time together this afternoon will be of great value as we learn how to effectively utilize ADR for the benefit of your clients, the court, and most particularly the public of this province. I would like also to acknowledge the individual who had the foresight to initiate this project, namely former and the late Chief Justice Frank Callahan, who was a longtime colleague of mine and a very close friend. As we all know, his contribution to the administration of justice in this province was enormous, and I am deeply saddened that because of his tragic death, he cannot be here today to see his concept of court-based ADR come into. As you are all also probably aware, Frank Callahan was also responsible for the creation of the commercial list. He realized at that time that litigants involved in the business process often require a quick and efficient resolution of their disputes, and that commercial cases affect not only business owners and shareholders and other litigants, but also employees and many others affected by commercial decisions. The ADR project is another example of his insight and a strong belief that litigants do require alternatives to the trial process in order to resolve their differences. In particular, our late Chief Justice recognized the need for the court, the bar, and the government to work together to bring about effective change to some of our traditional processes. The Adr Steering Committee is a very good example of how change can be implemented through cooperation. The committee, which consisted of members of the judiciary, the private bar, and the Ministry of the Attorney General, has worked very hard over the past 6 months to develop this project. I know from my days as the Attorney General of this province that committee work can be a thankless task consisting of a lot of hard work and often too little recognition. I'd like to thank each and every member of the committee for their contributions to this project and for arranging this important educational seminar. Now, traditionally, from the first day that we entered law school, we have been taught that the manner in which to resolve disputes is through the adversarial process, and cases are to be fought in court, and to the victors will go the spoils of battle. Our legal education has encouraged us to be good advocates and champions of the rights of our clients. And too often, courts have been viewed not simply as the last resort for resolving cases, but only too often the only resort. Now, each of you will have, as I do, memories of the old gladiator, the lawyer you knew or worked with, who was held in such high regard because he or she always went to trial. Looking back, you may ask yourself whether even if the lawyer won the trial, did the client really win the case? I often recall my own father saying, who was a trial lawyer for some years in this province, that used to speak about the famous British industrialist who in his memoirs wrote that he'd only been bankrupt twice in his life, and the first time was when he lost a lawsuit, and second time, of course, when he won the lawsuit. Now, taking a case all the way to a trial may, of course, not be in the best interest of the client. The ADR project will provide counsel with an opportunity to resolve cases more expeditiously and at a lower cost. However, I wish to emphasize that ADR is not expected to force counsel to settle cases which may have to be resolved by the trial process. ADR is simply expected to be another very important option. It is a new option which I hope competent counsel will wish to explore in an effort to ensure that he or she will best serve the interest of the client. Now, recently I have been traveling to many of the courthouses throughout the province in a continuing effort to listen and learn about the concerns of the justices of my court and the members of the bar. Counsel often complain that since our system is based on the adversarial process, a lawyer involved in a civil case who suggests mediation, arbitration, or ADR is often perceived by the opposing counsel as having a weak case. Now, certainly attitudes must change in that regard, and counsel should realize that suggesting ADR, mediation, or arbitration is not a sign of weakness, but indeed often a sign of strength, and in any event, a process that is not only about winning and losing, but about serving the best interests of all litigants. The traditional manner in which law is practiced in this province, in my view, must evolve to meet the needs of the clients who today are often far more sophisticated and demanding than perhaps clients of the past. The law schools in Ontario recognize this and are beginning to change the culture and attitude of the next generation of lawyers. Courses are now regularly offered negotiation, mediation, and arbitration. The fact that these courses are being taught in our law schools is, of course, recognition of the fact that negotiation and mediation skills are every bit as important as other advocacy skills. While law schools are meeting the challenge of changing the culture and attitudes of new lawyers, the judiciary and the bar also have a duty to continue to change our own attitudes. Seminars such as this will go a long way towards reaching this goal. As a matter of interest, in the province of Saskatchewan, a bill apparently has just been introduced which will require mandatory pretrial mediation, again, a recognition of the need to change the process. The opinion that I would hope that you would all take away today from this seminar is that court-based alternative dispute resolution will enhance your ability to effectively represent your individual clients. In many cases, ADR should be the ideal method for resolving disputes between litigants, particularly within the commercial field. Opposing litigants through necessity or convenience may have to have a continuing working business relationship after the dispute process has been completed. If in such cases litigants are required to proceed to the courtroom to resolve their disputes by way of trial, the delay, the cost, and indeed the trial process itself will often irreparably harm that essential working relationship. ADR, on the other hand, may provide a quick and inexpensive, relatively inexpensive method to resolve this dispute in a manner which will not destroy the working relationship between the litigants. You will note from the materials that initially the type of cases that have been selected to enter the ADR process is somewhat restrictive. The reason for this is twofold. First, it is important that the volume of cases entering ADR should not be so great as to overwhelm the new ADR center. Second, the committee wanted to channel those cases which could be most readily be resolved by the ADR process. I wish to emphasize, however, that if there is a joint request made to the court for mediation, the case will certainly be referred to the center. Now, as I conclude, I encourage all counsel to be proactive and take full advantage of this new procedure and discuss with the opposing counsel the feasibility of taking your case through the ADR process. And you will hear later today about client satisfaction. It is interesting to note that recent studies, the level of client satisfaction is much higher where clients have been able to mediate a resolution to a dispute compared to the level of satisfaction held by clients who have gone through the trial process. A litigant who leaves the process with a reasonable level of satisfaction is a litigant who will hold the administration of justice in higher regard. And the public today, as you all know very well, is very much concerned about the costs and the delays that have become endemic to the civil trial process. As Chief Justice of the Ontario Court of Justice, it is my duty to address these concerns. Initiatives such as ADR, case flow management, pretrial, civil blitzes, and other initiatives are definitely a step in the right direction. It is my goal to work in cooperation with the bar and the government to develop a more efficient and effective civil process. In closing, I would like to thank Justices Adams, Blair, and Farley, who have been spending a great deal of time in developing the ADR project. I have consulted with my Regional Senior Justice for the Toronto region, Mr. Justice Archie Campbell, who is also here, and a decision has been made to provide as many as 3 justices where possible to support this important undertaking. I'm confident that with your cooperation, advice, and enthusiasm, this ADR project will become a permanent fixture of the civil process. I do hope you have a most interesting afternoon, and I look forward to sharing it with you. Thank you very much.
If I could ask the members of our next panel to come forward, and Mr. Justice Campbell, I've got you on that panel whether you knew it or not, sir. While they're coming forward, I direct you to the first yellow piece of paper in your binder. It is a evaluation sheet. It will help us in the next presentation of this program, which happens in 2 days, and also in the future presentations. If you could fill that out either as you go today or at the end of the day, it will help immensely. The very next page after that is an index of what's in your book. This program is somewhat unusual in that the papers you find are not what necessarily each of the speakers are addressing. They are reference materials and they will be referred to along the way. But behind tab A, the first yellow piece of paper, is the actual practice direction that we're talking about, in case you were looking for it. I'll turn you over to John Keefe, who will chair the panel on why ADR now.
Let me start off by introducing the members of the panel. On the far left is Mr. Justice Adams. Justice Adams is a member of the Ontario Court General Division and has been a member of the Adr Steering Committee and an active promoter of the ADR pilot project. On my immediate left is Genevieve Chernecki. Genevieve is a practicing litigation lawyer, more recently dedicating a great deal of her time, if not all her time, to practicing in the area of mediation. She's the chairman of the ADR Subcommittee of the Bar Association and an active ADR practitioner. On my immediate right is John Gregory. John Gregory is with the Ministry of the Attorney General and has really been instrumental in getting the funding and driving the pilot project to its present form. On the far right is Lloyd Brennan. Lloyd is a representative of the Law Society, active with the Law Society and forming their subcommittee that dealt with ADR in the practice. Now let me start off by talking about ADR, why we're here, the rationale. And I'm going to talk a little bit about ADR generally, and others then will talk about ADR as part of a court-annexed process. For those of you who don't understand what ADR is, let me just give you a brief, very brief summary. Most people assume that ADR means arbitration. ADR means a whole spectrum of alternative ways of assisting clients to resolve disputes. We all, as practicing litigation lawyers, or those of you who are active litigation lawyers, know that very often cases settle at the courtroom door, and we've all been actively involved in settling cases. But there are many ways of settling cases, many different approaches to settling cases, and different techniques have been developed, a lot of them in the United States over the last number of years, where clients are assisted in negotiating disputes. It's not the typical format where they go to court and at the courtroom door the lawyers work out some sort of a settlement. The whole range of options would include things such as a mini trial where the clients put on a bit of a demonstration with their lawyers putting on part of the show, sometimes in front of a judge or a neutral, sometimes in front of an actual jury. This would be non-binding. Mediation, which is where the clients are assisted by a facilitator. Different other alternatives, including arbitration, which is binding. The ADR pilot project, just for your information, does not include arbitration, which is binding. It includes all the other options short of a binding result. So it's more in the range of mediation rather than arbitration. Now, just by way of background, and I'll share with you some of the experiences that are happening in the United States just to demonstrate to you what has been happening in the marketplace. Because the fact is that alternative dispute resolution is something that is being driven by clients, and the lawyers are really following the clients into ADR, and to a certain extent are being dragged into it kicking and screaming. About 5 or 10 years ago in the United States, a group was formed by the in-house counsel of the Fortune 500 companies who got together because they were mad as hell. They were sick and tired of litigation. They were having their whole budgets drained by unproductive litigation. And it's like that network movie where they stuck their head out the window and said, we're mad as hell and we're not going to put up with it anymore. And they formed a group that signed a pledge that said that where disputes arise between members of this association, we will resort as a first resort to alternative dispute resolution. Now, virtually every Fortune 500 company in the United States that has in-house counsel department is a member of that organization and has signed that pledge. Now, they did that because they realized that they had to take control of the litigation process. They had to take it, in effect, away from their litigation outside counsel because they didn't think that they were being serviced by their outside people. Now, another thing that's happening. In the United States, there are many court-annexed ADR systems that are bringing ADR to the public in a way that will promote it and make people aware of it. Apart from that, though, there are also private systems developing in the United States. And just as one example, in California, there's a group that has employed over 250 ex-judges, and they provide the full range of services, including facilities with flags outside and courthouses built in their own private court system. And the billings of that organization last year were $30 million. Now, when you combine the court system with that kind of private system in the United States, ADR is a fundamental part of everybody's litigation practice. Another example. Last week in the newspaper, I saw that the Toronto-Dominion Bank has just introduced as a promotion to make it the bank of small business, a promotion whereby it will provide mediation services for small business loans. So that in a small business context where a dispute arises, the one mediator will be appointed by the bank, one by the small business person, and a neutral will be appointed to resolve things like calling of loans, etc. So the TD Bank is obviously feels that mediation is good business and a way of promoting itself and distinguishing itself from other banks. Now, let me give you a couple of other examples of ADR and what's happening. ADR is not something that is necessarily inconsistent with litigation. And what everyone has to realize who's a practitioner in litigation today is that if you're not using ADR techniques, some ways of resolving disputes, then you're not properly servicing your client. Let me give you one example. I've done a fair bit of ADR, so I'm familiar with it, and I had a case where I just couldn't break the logjam with the lawyer on the other side. He just wouldn't budge on a case where we were asserting a claim, and we were facing a very long and expensive trial, fair bit of money at stake, but our client was getting tired of it. And the client basically said, I'm tired of it. I don't want to put up with it anymore. I don't want to spend any more money on it. So I was able to say to the client, all right, what we're going to do is we're going to convince the other side that we're going to go to a mediation. And all I want you to do is invest $5,000. It's all it's going to cost to pay me and this mediator to go for half a day. We'll try it on, and we'll see what happens. And if we don't get it resolved, then you can drop the case. We went. Sure enough, the first 2 hours, the other lawyer wouldn't budge, the other client wouldn't budge. At the end of the day, actually before noon, we came out with a settlement of $300,000. The client was delighted. I was delighted. I had a happy client. We went through the process. We never would have achieved that result through the normal litigation process. That's just one example, and I'm sure each of you have in your filing cabinet 1 or 2 files where you know you've got a logjam. You can't break that logjam. You've either got a client that's impossible, a lawyer on the other side that's impossible, or you are impossible. And one way or another, ADR, which forces people into a setting where there's some neutral that can look at the case and force the people to think about it, will likely achieve a result that you couldn't achieve through the normal court process. One last example, and this is an example that I heard yesterday. The problem with litigation is that in litigation, the result is only a money result in most cases. But apart from suing for money, there are a lot of different reasons why clients want to get involved in litigation. I'll give you a story. An American lawyer told a story that he was involved defending an action on behalf of a state trooper in Massachusetts. The state trooper had gone through a red light chasing a drunk driver and hit broadside a car with 2 teenagers in it, killed one of the teenagers. Teenager was the valedictorian in his high school, great kid. They defended that action on behalf of the state trooper, but they couldn't get a settlement. The plaintiffs were seeking an enormous amount of money and they wouldn't budge. No matter what they tried, they couldn't budge. Somewhere along the line, they decided to go to a mediation. And in the course of that mediation, the family was there, mother, father, sister, and they all told their story of who this boy was, what he meant to them, what his future held. And they were able, in the course of that meeting, to tell the whole story of this kid's life. The state trooper, on the other hand, was able to tell them how sorry he was, how he didn't feel that he had done anything wrong, but that he was sorry for what had happened. The case settled that day. The story is that the family really wanted more out of that case than money. The family needed an end to the story. And the sister came to the lawyer at the end of it and said, "We buried our brother 3 years ago, but the funeral was today." So that's just one example of how people in litigation are seeking more than just money. And in an arbitration or a mediation setting, a skilled mediator can explore these options and bring out more than the simple issue that's involved in the litigation. Now, ADR, in my view, is here to stay. We all have to live with it, whether we like it or not. The next question, though, will be, why are we doing it as part of a court process? What's the point of having the court impose it or suggest it or nudge people in that direction? And I'll turn it over now to George Adams, who will address the rationale for why we're doing it as part of a court process.
Unlike people from Revenue Canada, I can say on behalf of the courts that we're in this only to help you. And you might ask why. And it really centers on the strength of settlements. I think everybody in this room would agree that the settlement of litigation is much more preferable than an adjudicated outcome of that litigation when you can do it. And when we unpack that assumption, I think, a shared understanding that we all have, it's not just that it's quicker, because sometimes it's towards the end of the process, but it's often quicker. It's not that it's cheaper, because sometimes it isn't more cheap, because again, it can come at the end of the process. It is because the solutions are so much more diverse and rich and elegant than the outcomes that are available to us as judges in court. In court, we all know it's yes or no. You win big, you lose big. And most of our problems aren't that clear-cut. They're not that clear-cut factually, they're not that clear-cut legally, and they're not that clear-cut from a sociological or a psychological perspective. What's driving parties to have this conflict? The result of a more elegant, a more diverse solution is a more satisfying solution for the customers, for your clients. So our systems, our conflict resolution system, and the court is part of that, ought to be focusing very much on the development of settlements if they're so much more superior to adjudicated outcomes. Now, we know that you as lawyers spend most of your time settling cases. I mean, this isn't anything new. This is what you do. And you know, and we know, that these settlements are fundamental to the administration of justice as well. We've got big dockets and a tremendous public financial commitment to the administration of justice focused on adjudicated outcomes. And there's a growing awareness that the courts haven't been supporting your settlement efforts to the degree that they are important to the system, and that potentially there's more we can do to assist you in your settlement efforts. And why us? Well, we've got a big stake in the administration of justice. And secondly, we think we've got some credibility to assist in the institutionalization of alternative dispute resolution systems in this province. We feel that by the courts getting in now by way of this pilot project, that maybe we can prove the concept a little faster than if we don't. Maybe we can whet your appetites and your clients' appetites to the extent that whetting is necessary. There's a belief about the courts that the making available to you on a timely basis, mediation, early neutral evaluation, the involvement of a third party to assist and facilitate discussions between your clients can make a great contribution to the resolution of conflict in this province. And that's what the pilot project is intended to look at. Our hope is that it can make a real contribution to access to justice, and that it is the beginning of reasserting the courts as centers of conflict resolution in society, as opposed to simply a place you go to have a trial. The thought behind the project is that you come into the court system with a dispute. One of the ways to resolve that dispute is by a trial, and we'll continue to provide that service. But when you start the dispute with us, the belief, and I think it's a shared belief, is that there's no preconception that that's the way that matter is going to be resolved, and we know empirically that 95 or 98% of all the cases that come into the system settle, are not adjudicated. The problem is they settle too late in the process, and they often settle without sufficient support by way of third-party facilitation to assist you in devising the best negotiated outcome possible for your case. The court intends to, as the Chief Justice indicated and as the Senior Regional Justice has committed, to free up judicial resources, and the province is assisting in the hiring of dispute resolution officers, and this judicial and non-judicial unit is going to make itself available to you at the front end of litigation to engage in every effort to assist you in settling your cases early. I think it can be said in conclusion that we, in developing the project and in targeting it to the front end of litigation, We are wanting to get settlements as early in the process as possible, because that is of great benefit to your clients. But we don't want to distract you from making efforts to settle your cases at all times, and to look at this program as being available to you at any time in an effort to settle cases. Thank you.
Perhaps now we can turn to Genevieve. Genevieve is a practicing private service provider in the mediation field, and can bring some insight as to the rationale for ADR, the benefits, and how that's going to work within a court process.
Thanks, John. Well, in focusing on this particular component of the program, I was mindful of the fact that this was about a rationale. So I tried, from what I knew about this Court-annexed program, to examine what I thought the rationale was. And Justice Adams will be relieved to hear that I came up with substantially the same thing as he said. That is to say, I think this Court-annexed ADR initiative is a commentary on the response of the public and the profession to ADR generally. There has not to date been an excessively high volume of experimentation with alternative dispute resolution techniques. The response has been a slow and a gradual evolution or experimentation, as anybody who's quit their day job will tell you. But I think the response has been slow based on the fact that at the heart of the adoption of ADR is an educational process where people are finding out what this is conceptually, they're thinking about it, they're assessing the risks of the known and the unknown, and then they're trying it out. And in marketing terms, what I perceive to be going on is that people are really still gaining product knowledge. They're not anywhere near gaining brand knowledge. Now, the Court-annexed initiative is, as I see it, an attempt to accelerate the experimentation with ADR and the adoption of ADR by presenting it as part of the court process. And what we really have here are the courts and the government lending their institutional credibility, which was Justice Adams' point, and the weight of their authority to these ideas, and saying to you and to your clients, we have determined that these things are good, we have determined that these things are in your interest, and here's an opportunity for you to try them. Now, the challenge, I think, that rests with the practicing bar in particular is to determine what are the cases where this is good for clients, and what are the cases where this is in the interests of clients, and what are the appropriate processes. I certainly think that the Court-annexed initiative does have the capacity to enhance the credibility of ADR by association. Certainly the number of people that are here today is a surprise to me. I would not have expected this many people to come and listen to a program of this nature. And I suspect that that has something to do with the fact that ADR is now being mated to the litigation system. And there's a certain amount of, shall we say, compulsion involved in the practice direction. I often think of ADR processes as being very similar to environmental concerns. If you think about how the green movement and so on started, it was very much something that started at the fringe. And then when it became adopted by major corporations and other interests as something of utility to them, it became something of more credibility and more general acceptance. Now, I think the fact that this program has the capacity to enhance awareness about ADR is enormously important to the practicing bar. If you think about what ADR really is, and I would suggest to you that in every case where you hear someone use the term, you should check out what they mean by the term ADR. As John pointed out, some people think it's synonymous with arbitration. Some people think it's synonymous with mediation. They use ADR. They mean one particular process, or they mean another. Some people think it means everything outside of the courts. Some people think it means the courts included. The definition that I use for ADR is an inclusive definition, such as the one that has been suggested here today, that it is a body of knowledge a body of process knowledge that runs parallel to what a lawyer is presumed to already know. And a lawyer is presumed to already know the substantive law and the rules of civil procedure. So it's a range of choices for the resolution of all or part of a dispute. And at the core of it, certainly from my perspective, at the core of it is the concept of self-determination, which means that people can accept or reject whatever process they think is in their interest. They can adopt it, adapt it, or reject it. And sometimes that means they will pick an adjudicative model, and sometimes that means they will pick a negotiated model. And I think this concept of self-determination and voluntariness does raise some issues for the practicing bar when you're looking at something, when you're looking at a court-annexed ADR process. To the extent that the court-annexed project enhances information about ADR and puts people in a position to make informed procedural choices, then it's a good thing. Because, after all, ADR is about voluntary, self-determining procedural choices. But the question I think that we have to pose for ourselves for the future is, what happens when we mix voluntary procedures with the courts and with judges? It's been mentioned that there are a number of court-annexed ADR initiatives in the United States and in other jurisdictions. Fortunately, in this jurisdiction, there's been the good sense to avoid the arbitration component. In a lot of American jurisdictions, what people are compelled to do is to go to they call it a non-binding arbitration process, where you come out the other end with a decision, and you can choose to adopt it or not. But if you choose to reject it and go forward with a trial, then you may be penalized in costs if you don't do any better when you go forward to trial. So there's been a lot of criticism in the US around the idea of really sandwiching in a process that people didn't ask for, which delays them from moving forward with the litigation process if that's what they choose. I should also comment that I was recently completing a position paper for the Federal Department of Justice on ADR and litigation, and that obliged me to review a lot of the literature. And I found in there some commentary on court-annexed programs, and one thing that I read particularly struck me was by a British author who was commenting on some of the risks associated with court-annexed work, and he identified, courts are places where dominant seniors tell us what to do, and judges are equipped with coercive powers in the event of our failure to comply with their orders. And this author says that when you're in an adjudication, the rules are clear, you know who's telling what to whom, but when you mix the more negotiated-based forms of ADR, like mediation, with the courts, then the rules become a bit fuzzy. So my suggestion is to you, in going forward with the program, that one of the things you need to think about is, what role does the judge's office play in this process that we're engaged in? And am I making sure that my client is making an absolutely informed choice based on the range of options available to him or her? And can I know when and how to say no? I think that's something that we need to keep in mind, because no one here today would suggest that ADR in each and every case is going to be successful and it's going to be useful. The second thing I think we need to keep in mind, and it hasn't been mentioned yet, is that there will also be officers called dispute resolution officers who will be employees who will be performing some ADR processes. And one of the things that needs to be given thought is, to whom are these dispute resolution officers responsible? Are they responsible to the courts? Are they responsible to the Chief Justice? Are they responsible to the Attorney General's Department? Are they responsible to the Law Society? Or are they responsible to the parties? And this becomes significant around, well, what happens if it doesn't work? Or what happens if somebody misbehaves in a court-annexed ADR process? In Washington, D.C., where there is a very big, thriving court-annexed initiative, there was a case where he was called an evaluator, formed the view that somebody wasn't participating the way he thought he should participate, and the court evaluator asked to be excused from his role, and he wrote to the judge to say, I need to be excused. But in the course of writing to the judge, he also commented that this was a case that should be settled, could be settled, and it was the behavior of plaintiff X that was causing it not to be settled. Now, any private mediator would do that twice, their first and last time. And this mediator should have been kicked severely out of the program, in my view, and he was sued by the person about whom he'd made the remarks. And interestingly enough, the court said, and I have the case up here if you want to take a look at it, these court-annexed people are really new creatures, and we're not too sure about them, and we haven't really thought about what happens if they irritate one of the parties. But you know what? This evaluator really enjoys immunity. So, c'est la guerre, right? And I think that this is really something that needs to be thought about. I noticed that in the practice direction, there's a mention made that no record of the ADR session, if it fails, is to be communicated to the trial judge. But such was also the rule in this particular Washington-based program. So I see the watch is here. Thank you. That is the hook. Let me just wrap up by saying, I raise these points as things for us to think about because, after all, one of our fundamental jobs is to think and to evaluate. I also urge you to participate in the program. I think at the end of the day, if the program raises awareness, that is wonderful and good, but maybe ultimately it should have only a 2-year life, and at the end of the 2 years, when we are all better informed with an experiential base, it can be discontinued, and we and our clients can make informed choices on our own about the processes that we think are in our best interests. Thank you.
One of the points that Genevieve raises is a good one, relating to the new body of jurisprudence that's going to arise surrounding the practice associated with court-annexed ADR. Throughout the United States right now, there's a whole new body of law developing about the proper practice and procedure. There is no doubt, though, that this is a pilot project and it is experimental, and we're all going to have to work together to work through the process to make sure that it works in everybody's interest. I'd like now to turn to Lloyd Brennan, who will provide some comments on what he considers to be the major rationale and significance of this program from the perspective of the practicing bar.
Thank you, John. I just want to deal very briefly with the perspective of the Law Society. In your materials at, I believe it's tab B, you will find a complete copy of the report of the subcommittee on alternative dispute resolution, called, in fact, the Dispute Resolution Subcommittee. It was one of our early decisions in that subcommittee to drop the use of the word alternative. We want the message to go out to every practitioner that all of the spectrum of dispute resolution methods that are dealt with in that paper, and that you'll hear discussed today, I'm sure, over the afternoon, belong to us as advocates. That's really our business. It's not an alternative to our normal business at all. It's part of our normal business. The rationale for a court-annexed ADR program is indeed, as previous speakers have suggested, including and perhaps especially Genevieve, in that this is a kind of kickstart. ADR has been coming for some time, and our profession has, in effect, looked away, has buried its head in the sand in a rather typical fashion. The Law Society, in formulating or in forming this subcommittee, recognized the need to be proactive rather than reactive to this very important development in the marketplace for advocates' services. And so we worked with, if I may be immodest about it, a truly excellent committee. I commend to you the list at Roman numeral small letter I of members of that committee. We had some people there who really are the leading lights in this province, indeed in the country, on the subject of dispute resolution, alternative methods, a great range of them. The late Gordon Henderson, the Honorable R.E. Holland, QC, and a number of practitioners who are familiar with this material in a most direct way. Well, let me just give you some of the thoughts that I shared as chair of that subcommittee when I presented the report of the subcommittee to convocation. The first and perhaps most important thing that I hope you will take away from today's session and carry in your consciousness is that no one is asking you to stop being an advocate. Advocacy is absolutely our business. That's what we are about. The suggestion that the old adversary system is too narrow a scope for us to resort to, too narrow, too small a box of tools, if you like, for us to resort to in order to be advocates in the 1990s. That proposition, I suggest to you, is one that's been very well demonstrated. And it's time for us, as members of this profession, to catch on and indeed to move ahead of the marketplace. One of the things that's dramatically clear is that there is a terrific demand, a pent-up demand, for alternatives to the usual litigation paradigm because it's simply too costly. It simply does not serve for the small dispute. Small in dollar terms, small to us who litigate for a lifetime, small to us who have overheads that are simply staggering. Don't have to be on Bay Street in Toronto to have very high overhead in the litigation business, but mind you, that's one of the examples. We're just too expensive if we continue with the litigation paradigm for the kind of dispute that most people have in their ordinary everyday lives. They need help with those disputes, and they haven't been getting it from big-time lawyers for a long time now. And the fact is that there are very few members of our profession who can today act in the traditional way for a client in an action that involves something like $10,000 in value or a point of principle that may have no monetary value. That just won't do anymore. We simply can't live with that and continue to hold our heads up and say that we are the advocates to whom the public can turn when they want to access justice. That's really what this is all about. Justice is the virtue, the goal, the ideal that all of this is meant to serve. And the fact is that we've allowed ourselves to fall behind the economic laws of the day that make it impossible to do justice using those old methods which are simply too costly and take too long to get to. If I can make that point in a much more summary way, advocacy is not equivalent to adversity. The adversary method is a superb and excellent system for testing the truth where truth is truly contested. You need a court, you need a trial, you need a judge who is impartial, and it has to be a representative of the state who sits in judgment in a substantial number of cases, but nothing like the number of cases that are on our waiting list in the civil litigation system. That's not really a trial list at all. It's a stall list, and we've allowed that to happen as a profession. We've got to change that, and one of the ways, some of the ways, I guess I should say, that we can change it are found in the notion of alternatives to our traditional dispute resolution. Now, the fact is, I think all of us knew that. At law school, we've known it for years. But the practice is that virtually everything gets put into the litigation hopper. And it settles. 95% of these cases settle without trial. Probably something like 95% of them never belonged on a trial list, should never have been in the trial process. Now, maybe that's a little too high a percentage, but certainly the percentage is higher than the 10 or 15% of cases that lawyers actually do now refer to some other method than the litigation system. Well, I've spent a lot of time on that sort of statement of principle, but I suggest to you that that really is the rationale for the project that we're now seeing. The court has responded to the need. An initiative is being taken which has, as Genevieve pointed out, a number of advantages that will move us, hopefully, into a new time and a new paradigm. Mr. Justice Adams makes the point that too many cases settle too late. Of course, that's true. The fact is, a great many things should be settled sooner. John Keefe's example of the family having lost that young man who had such a future before him, needing a hearing. The last thing they needed in the world is a trial, but they needed to be heard. They needed to express the value of that young man's life. And indeed, that process, a process of some kind of hearing, worked in that much more beneficial way. Another little thought that comes to my mind as I listen to some of my colleagues here, one of the jokes in our profession is that when we lose at the end of a trial and walk out of the court with that beaten up feeling, and somebody says, "How did you do?" and you say, "Well, okay, I guess I came second," which means I absolutely lost. Fact is, coming second should be a highly respectable achievement in a great many of our files. And there ought to be a way in which you can come second and still serve your client very well. There are lots of ways, and you'll find them at page B67, B67, I'm sorry, it's A67 of the B reference. Yeah. It looks like that. It's at the end of that B section. And that's just a simple condensed spectrum of ADR approaches that you should be aware of. None of it is very surprising. Certainly none of it is new. It ranges all the way from prevention, what most good solicitors spend their lives doing, right across the whole spectrum to a trial by a judge or someone with the authority to invoke the state's sanction. I leave my comments there, and John?
Okay. The one point that I think is significant arising out of Lloyd's comments is that this ADR project is really forcing lawyers to view their function in a slightly different way, or perhaps even a dramatically different way. And that will be part of the learning exercise that we all go through in the next little while. I'd like now, though, to turn to John Gregory from the Attorney General's Department and see if he can bring some insight into the perspective of the government, of the Ministry of the Attorney General, to the rationale for a court-annexed ADR system.
Thanks, John. The Ministry of the Attorney General is, of course, a fairly substantial player in the administration of justice in the province. I think its interests are twofold. One, of course, is promoting, maximizing, optimizing the access to justice, which deals, of course, with a quantity, ensure that those who want to have disputes resolved can get them resolved, and a quality aspect, those who are getting their disputes resolved get a good resolution. And we've heard a good deal from the other panelists of various ways in which ADR can promote access to justice. The other interest that the ministry has in the administration of justice is, of course, the financial effectiveness of the system. And when it comes to going to Treasury Board and saying we'd like some money to set up a pilot project, Treasury Board's priorities tend to be the financial effectiveness of the system, at least as much as, if not more than, access to justice. So I will speak just to the financial efficiency side of it, because the access to justice has been addressed elsewhere and will be addressed by later speakers, not because the ministry doesn't think that that's the priority. I should also, as representative of the Ministry of the Attorney General, advertised as such rather than by name on the program announcement, echo the Chief Justice's comments. This whole project was thought of first by former Chief Justice Callahan, and without his coming to the ministry and saying, what about it, and without a number of the judges that the Chief Justice today mentioned making sure it happened, it wouldn't have happened. The ministry was delighted to go along, and I think we've had a fairly good team on the steering committee since the steering committee was put together, but it's definitely one where the ministry is cooperating with the court rather than trying to pretend that it's out in front. There are two targets to the IDR pilot project from the point of view of the ministry. One of them is backlog and the other is new cases. The main focus, as you can see from the practice direction, or as you will when you've read it, is new cases. We're going to focus on keeping the cases flowing through. There are other things that may be done to the backlog over time, and various ideas come from various quarters on dealing with it, but it's something that the project may also address its mind to, in the sense of referring cases from the backlog to the ADR Center from time to time. Will also allow us to evaluate whether old cases settle better than new cases and so on. The other reason that we're interested in having some impact on backlog, of course, is because the greater the backlog, the harder it is for the case flow management project to succeed, since it depends on fixed trial dates, and the more old cases you have, the harder it is to give those. And certainly there are theories that the longer the case is in the system, the more likely it is to stay in the system. The less likely the parties are to settle it because they've got more invested in winning it. Of course, the other side of that is people get fed up or run out of money. So we'll have a selection of cases. We'll be able to test both those theories. But I think there's a fair amount of sympathy for the prior suggestion, that is, get it new, get it before people are deeply into their trenches, get it at a point where they're still thinking about their interests and not simply about the result of the case, get it before the clients start thinking like they're lawyers, and defining the cases essentially in litigation terms, win-lose terms, and you may be able to get farther at getting a useful settlement. I wanted to talk very briefly about where the government thinks there may be a saving of money to the government in this. Certainly maintaining a case in the court system costs money. There's some material in Justice Zuber's report in 1987 on the administration of justice in the province and on the court system that deals with that. I mean, there's a handling of paper and documentation. There are motions, there are pre-trial conferences, all of them not just to do, but to paper, to have the files moved back and forth, to have people involved, not only the judges, of course, who are going to make the decisions, but the various supporting people who have to make the things happen. There are the actual trials that proceed, and of course the trials that proceed at greater length than they need to because of the fact that the parties haven't sufficiently defined their terms or defined their cases or thought of their issues. Of course, pretrial conferences are intended to address that, and in some cases do, and in some cases don't. And of course, there is a good deal of waste to the system when cases settle at the last minute. I mean, I had an experience myself lately where I was a witness in a case, and I went and I spent the afternoon sitting outside the courtroom while the parties talked about settling. And the plaintiff's lawyer, I can't remember which side, whichever side I was witness for, it didn't matter. I never got into court because after 3 hours of sitting in the witness room, the case settled, and they said, "Thank you, you can go away now." Well, that's all very entertaining, and I was able to do some business through my voicemail thanks to modern technology, but it was basically a witness who never did find out what happened in the case. And the judge presumably was sitting in his or her chambers waiting for something to happen too. It was a waste of time, when not so much my time, which isn't part of the court system, but it's certainly a waste of the judicial time and the other people. If the thing had settled 3 weeks earlier or 3 months earlier or 3 years earlier, all of which would have been possible in ample time after the statement of claim, then there would have been a lot more resources that could have been put to resolving the case that couldn't settle. And one suspects that they don't settle simply because people don't go around to looking at the file. They don't take it seriously until somebody else is about to make up their mind for you. What we're hoping to do with the project is cut down the numbers of cases that happens to. The Toronto region of the General Division received about 60,000 statements of claim last year. We figure about 35,000 might be eligible for ADR in some way. We plan to take cases only once they have had a statement of defense filed. Statements of defense are filed in about 25% of cases started, which is remarkably small. Talk about the cases that shouldn't have been in the civil justice system at all. About 40% disappear entirely. They come in and you never hear about them again. About 35% have default judgments. We probably make money on those given the filing fees, but it's still, you wonder whether that makes any sense from a point of view of administration of justice. About 7,000 a year go on the trial list, having got at some point between there about 25,000 motions in a year. The average civil non-jury trial lasts 4 days, a jury trial 5.5 days. Those averages include the cases that settle before the end of trial. If you compute the costs of the ones that get to those late stages, when you start having intensive judge time and intensive support staff, paper flow management time, and you consider that the ADR Center may handle a certain number of cases, and we're projecting over a couple of thousand cases a year, depending on how long it takes. It's a pilot project. The pilot's allowed to steer during the course of the voyage. And we compute that some percentage of them will settle. And how are we going to do? Are we going to say we're going to bat 50-50? Maybe we'll bat 50-50. You can cut out, I think on a rough calculation, hundreds of days, even 1,000 days of trial time in cases that would have gone to trial based on the percentages. About 15% of the cases that get to the trial list go to trial every year. So there are a lot of places that permit serious savings of time by early attention. And I have pages and pages of statistics that persuaded Treasury Board that it was worth at least taking a shot at. I think the end of the day, at the end of 2 years, we're going to have to face the question that Genevieve raised from a financial point of view as well as an access to justice point of view, which is, do we, the ministry, do we, meaning you, the Ontario taxpayer, continue to support a court-based project, or do we say, well, let's let the private sector pay for it, let's let your clients pay for that part as well as the other parts. Part of the result of that will be simply how are we doing? I mean, if the project is settling a huge percentage of cases, then that may be enough advertisement for the product knowledge, as Genevieve called it, to say, good, this child can walk. On the other hand, it may be so persuasive to the people who are worried about the case flow and preventing backlogs from continuing that they may say, no, if we can make this thing run by ourselves that way, we're going to keep running it. So it will be partly an economic decision at the end of the day whether it will run, and it will be partly a policy one, and we'll be interested in both sides of it.
But surely, John, just to throw the counterpunch in here so we can end on a counterpunch, the Ministry of the Attorney General can't just look at this from the perspective of the cost saved in terms of courtrooms and judges. If people are actually getting better access to justice and a better result, and they're happier and they're saving time and expense and money, and witnesses aren't being inconvenienced, certainly that's something that should be of interest to the Ministry of the Attorney General. That's something that's in everybody's interest, and there's more to providing justice than just providing rooms.
Oh, I agree, absolutely. That's why I started to say the ministry has an interest in access to justice, and quality justice, and it wants to promote that. But when it's a matter of saying, from this pilot project, assuming it is successful in increasing the satisfaction as well as in cutting costs, how do we best continue that? What is the essence of it? Is the essence of it that it has the credibility of the court, as Mr. Justice Adams says, or is it the essence of it that people have learned that this is a credible way of resolving their clients' disputes, and they can do it without our help now? I mean, that's the debate that we're going to have, and the people at Treasury Board will certainly raise it. And there are ways of raising it that I haven't got time to go into now, but it's certainly an issue that will be presented.
And also, just to end also on one note of controversies, one of the pardon me?
What's going on here?
One of the other controversial issues that the private service providers have is that, is this going to take away business from them? And I think over the course of the 2 years, what we'll find is that this will be the greatest promotional event for them that they've ever seen. And at the end of the 2 years, they'll be getting more business via the court system and via people who are now aware of a range of services that they weren't otherwise aware of. Now, Don, is that it for our time? 2 minutes over. All right. Thank you.
While Genevieve is leaving, I want to thank the CBAO for making available the directory of ADR professionals. It is in your material at the back, as well as some material on one private provider who made material available to us. The pilot project can't deal with every case that wants to have those services, and we make you aware of the people who are available to provide it as well. Our next speaker is Professor Paul Emond from York University, Osgoode Hall Law School, and he's going to deal with an overview of ADR techniques.
John, can you leave your watch down there beside me? Thanks very much. Thank you very much, Don. As you know from the program, this was described as available ADR services, and I had originally thought that I might spend some time talking about how you select an appropriate person to provide that service. As Don points out, you do have the directory of people who offer these kinds of services, and they are in the material under the last tab. I might say, if there's a moment or two at the end, 2 or 3 things about the kind of characteristics you should be looking for purposes of selecting the appropriate dispute resolution officer or ADR professional. But before I get to that, if indeed there is time, let me take the 15 minutes available to me to take you through, I think, some of the highlights of the services and techniques that may be available to you. First, I would like to echo a comment that others have made, and that is that there really isn't anything new here. Indeed, I would go further and say that the best lawyers have practiced ADR, which might be better defined as appropriate dispute resolution as opposed to alternative, through all of their practice career. I think that the people who've been most successful in representing clients are people who've understood processes, not just the adversarial or the litigation adjudication process, but indeed every process. I think if you can, for a moment, imagine processes falling on a continuum. At one end of the continuum is negotiation. At the other end of the continuum is adjudication. Most lawyers understand the 2 extremes of that continuum very well. They know that negotiation is a part of what they do, and they know that litigation is a part of what they do. What I suspect most lawyers don't understand very well are the parts of that continuum that fall in the middle: facilitation, arbitration, mediation, and a whole series of hybrid forms of dispute resolution that have come to be known as the mini-trial, med-arb, to name just a couple. Well, let me talk for a moment about the obstacles that have made it so difficult for lawyers to understand and to practice what falls between the 2 ends of the spectrum. First, I think, and perhaps most obviously, lawyers come to the business with a philosophical roadmap that tends to be characterized by one of adversarialness. They regard disputants as adversaries. They believe that most disputes are best resolved by the application of predetermined principles through an impartial third-party decision maker. They are disinclined, I think, to believe that there may be another equally successful philosophical roadmap that emphasizes creative problem solving. that emphasizes creative solutions, that emphasizes that most situations are unique and therefore not to be governed by any predetermined or general rules, but rather to be solved by the creative efforts of the parties themselves with the assistance of their lawyers. Well, there we are, two ends of a spectrum. As I say, I think lawyers understand better the adversarial, the litigation end than they do the negotiation end, but they do understand the negotiation end. What is it about negotiation, or at least the way lawyers practice negotiation, that makes resolution of these issues sometimes so problematic and people inclined to resort to adjudication? Well, first, I think that the kind of negotiation that takes place in the shadow of the court. I think most people, when trying to negotiate the resolution of a dispute, try to replicate what they believe a court would do if the matter went to litigation. And that has an extraordinarily confining and structuring effect on the way in which the parties undertake negotiation. Secondly, I believe that most people, when they negotiate in a way that's often described as positional negotiation. They assert positions on behalf of their clients. For those of you who haven't read Fisher and Urey's little book, Getting to Yes, there is another way of tackling negotiation, and it's often described as interest negotiation. Look behind the position of your party, the position of the other party, to understand the interests that that person is trying to protect, and then rather creatively look at ways in which those interests might be furthered in the context of some creative solutions. Secondly, I believe that most people in the course of negotiation engage in something that might be described as a kind of distributive negotiation. Whatever your client gets, my client loses. Whatever I get, you lose. There is, in other words, a fixed pie. There's only so much on the table, and what I take means there's less left for you. Again, I think the best and the most creative lawyers look at ways of expanding the pie, ways of creating something bigger so that everybody can win. I must emphasize this is not so easily done. But with the appropriate degree of creativity, I think it's possible. So again, I return to a spectrum that sees negotiation at one end, litigation at the other end. I say that lawyers tend to focus at each end of the spectrum, and at the negotiation end, I think their negotiations, by and large, tend to be hampered by some of the factors that I've described. Well, let's look now in the middle at what is normally described as ADR, or dispute resolution. And by the middle, I mean facilitation, involving the assistance of some third party who might assist in some way in the negotiations, facilitate the negotiations. Moving along the spectrum, let's add or look now at a mediator, and let's divide mediation into two categories. The passive mediator, who acts very much like the facilitator, assisting the parties to reach agreement, but playing no particular role to ensure that the agreement that's reached is in some sense a good agreement. And we can debate, I suppose, for a long time about what is a good agreement. But this mediator's task is only to assist the parties to reach agreement, and not to pass judgment on the process by which agreement was reached, or indeed the agreement itself. Needless to say, that is given some people in which, for instance, there is an extraordinary power imbalance between the parties, cause for concern about involving this passive mediator whose duty seems only to achieve agreement and not to worry about the content of the agreement. Next step on the spectrum towards litigation is the active mediator. Now, this person and this process is sometimes described as muscle mediation. The mediator does play a role. Indeed, when judges perform this role as mediators, they often assist the parties by performing what might be regarded as some sort of a reality check. The position you've put forward is not realistic. It's not going to take you anywhere. Be reasonable. Be more realistic. That's a role that a mediator can play if the mediator has some independence, the respect of the parties, some standing, as a person with integrity, not likely to prefer one position over another. That's the role of the, if you want, more active mediator. Sometimes that process is described as muscle mediation. Move to the next step along the continuum. Now we introduce the arbitrator. Here the role of the third party is not to assist the parties to reach agreement, but the role of the third party is very much like that of the judge, to issue a decision that's binding on the parties. We could talk a lot about who appoints the arbitrator, the role of the arbitrator, whether the arbitrator's decision, or rather award, is binding or non-binding, a whole range, if you want, of options that are available here. The important point to note is that this is essentially a third-party imposed decision on the parties. Note that as we've moved along this continuum, we've moved from the voluntary, the consensual, face-to-face negotiation by the parties with a view to achieving an agreement. And as we've moved along the continuum, the process has become less voluntary, ultimately ending in adjudication, in which there is no voluntariness, less consensual, in which the result is not agreement among the parties, but a decision imposed, less a process that involves only the parties and more a process that involves intervention from some third party, and so on. So the continuum, as I say, moves from one end of the continuum or spectrum to the other. Now let me mix up processes a little bit, because it seems to me that no single process will necessarily resolve every problem. Indeed, you may find, in the course of a dispute, that there is a dispute over a factual matter. Very little point in negotiating a fact. It either is or it isn't. So rather than negotiate, or indeed rather than litigate, why not turn to another process such as the employment of a neutral a neutral fact finder to investigate and report to the parties. The report may be binding, it may be non-binding. Let me also assume that the assistance of a mediator is not sufficient to enable the parties to resolve the dispute. What you'll often find is that most parts of the dispute can be resolved, but there remain 2 or 3 very difficult issues. They perhaps are issues of rights, or characterized as issues of rights by one or both of the parties. It may be appropriate in those circumstances to employ something called med-arb, or mediation followed by arbitration, in which 2 options available now. The mediator who assisted the parties to reach agreement, or in this case partial agreement, acts as the arbitrator and arbitrates the 2 or 3 last outstanding issues. There are some advantages and disadvantages with that person playing both roles. Assume the disadvantages outweigh the advantages, therefore involve another party, a second, third party if you wish, who acts as arbitrator with regard to those 2 or 3 outstanding matters. How are those matters to be resolved? Well, rather than in the course of a full hearing, which might be characteristic of a normal arbitration, let's compress that into a summary format in which the parties agree that the procedure that will be followed is one in which no more than 2 witnesses will be called, no more than half an hour per witness, no more than, well, you can imagine. You can design the process that fits the needs of the parties, and providing you have the right person, sufficiently well-trained, knowledgeable about the dispute and procedures, I think you can get a perfectly satisfactory resolution of those 2 issues or 3 issues that could not be negotiated even with the assistance of a third-party facilitator or mediator. The point that I want to emphasize is that there is virtually no limit to the processes that are available to you. What's necessary is that you employ a new level of creativity in how you resolve these problems. What's also necessary, it seems to me, is that you turn your mind, as people who are schooled in processes and schooled in understanding disputes, to seek a better fit between the dispute and the process. Some disputes, disputes about rights, disputes about right and wrong or how much, constitutional disputes, for example, charter disputes, obviously belong before the courts, and that's where they should go. But there will be a whole variety of other disputes, especially commercial disputes, in which the nature of the relationship between the parties is ongoing, the necessity to find a lasting, durable, to pick up some words from Justice Adams, elegant solution, requires that the parties sit down, perhaps with the assistance of a third party, and create this creative and elegant resolution of the parties so that there is the potential for the two to go on and work productively together. Well, in the remaining minute, what are you looking for in this extraordinary third-party dispute resolution official? I think you're looking for a person who does this, who acts as a catalyst, who is an educator of the parties, who translates positions to the parties in ways that are less confrontational and less adversarial, who expands the available resources to the parties, who sometimes is a bearer of bad news, who is often an agent of reality, and is very often a scapegoat. And what characteristics will you look for and when looking for a person like this? First, a person who appreciates the dynamics of the environment, a person who's intelligent, creative, a good listener, articulate, patient, non-judgmental, flexible, forceful and persuasive, imaginative, non-defensive, full of integrity, humble, objective, and neutral. I'm sure there are lots in the directory who fit that prescription. Thank you very much.
Thanks, Paul. That's a super overview. You will see in the materials that I've given you a number of pages that flesh out what Paul was able to squeeze into 15 very valuable minutes. There are now 15 valuable minutes to allow you to have some coffee, and then we're going to go straight into the practice direction at 3:15.